from Nebraska Appleseed, and thank you for joining us today. We're going to go ahead and get started. As I said, my name is Sarah Helvey, and I'm a staff attorney and director of the Child Welfare Program at Nebraska Appleseed. So a little bit of background before we jump into the substance of what we're going to talk about today. I want to just mention a couple of words about Nebraska Appleseed. Hopefully most of you are familiar with us, but Appleseed is a nonprofit, nonpartisan, public interest legal advocacy organization, and we work in the areas of child welfare. We do work around healthcare access, immigration policy, and then poverty, public benefits advocacy. And we like to say that we use all of the tools in the advocacy toolkit. So we do a lot of work at the legislature doing policy advocacy, and in the community doing grassroots organizing. But we also have a number of attorneys at Appleseed. So we do legal advocacy as well, including impact litigation. And then we have within our child welfare program what we call the Foster Care Reform Legal Resource Center. And within that, we provide technical assistance and other resources like amicus assistance to attorneys, to help attorneys like you to create more positive precedents in juvenile court cases. That also helps us to identify some of the needs on the ground for systemic policy change. So I just want to put a little pitch out there that if you are work as a guardian ad litem or as an attorney for parents or foster parents and you're not already on our listserv, we invite you to sign up. You can sign up on our website. That's neappleseed.org. And we send a monthly electronic newsletter with case law summaries, legislative updates, and a policy spotlight. And we also invite you to contact us if you have systemic issues that arise in your individual cases, and we may be able to, to be of assistance in that area. I also want to make a little pitch that we are also having a webinar tomorrow, so I'm just guessing that if you are on this webinar today, on December 16th, you may be needing some late in the year CLEs, and my colleague Robbie McEwen is doing a webinar tomorrow at noon. It's an ethics, a free ethics CLE. It's going to be on the new guardian ad litem rules and rules of professional responsibility related to being a guardian ad litem. So if you're interested in that, you can shoot me an email. There is a contact information on the last slide. Okay, I'm going to give just a little roadmap of what we're going to be covering today. I'm going to be giving an overview of a new federal law called the Preventing Sex Trafficking and Strengthening Families Act, including an update on implementation efforts around that federal law in the state. I'm going to be talking a bit, there's kind of two pieces, two big chunks of that bill. A portion related to trafficking, kind of the Preventing Sex Trafficking part of the Preventing Sex Trafficking and Strengthening Families Act. So I'll be talking a little bit about the trafficking provisions, the Nebraska law, and then you have a resource in your materials that we created at Appleseed for attorneys specifically in the child welfare system related to trafficking, and I'll walk through some of the tips in that. And then I'll talk about kind of the other part, the strengthening families part of, if you will, of the Preventing Sex Trafficking and Strengthening Families Act. And then we'll kind of drill down more on the normalcy side of it. And so within each of those provisions, I'll give an overview of what the federal law now requires, and then an update on the status of current Nebraska law and policy. And then within each of those, I have some list of questions and considerations to kind of raise on the practical level related to those. And then hopefully we'll have time, and you'll kind of lean forward in your seats and type me a question if we have time for discussion and questions at the end. So there is a chat function, and you can chat me questions in there. You can really send them throughout the presentation, and I'll be kind of glancing over there and trying to answer them. And that's the same way that you can raise a question that you have at the end. And let me just, while we are here, look at that and see what I have. Okay. I think that we don't have any questions. I saw something, but I think it's not a question of the substance. But if you have a question, you can add to the chat function, and we'll get to it. With that, I'm going to jump right in here. Okay. Okay. The Preventing Sex Trafficking and Strengthening Families Act was passed by Congress and signed into law in September of 2014. Some of the provisions went into effect immediately upon enactment in September 2014, but the bulk of them went into effect a year after enactment on September 29th of this year. And then some of the other provisions are phased in up to 7 years after enactment, but most, particularly the normalcy provisions I'll be talking about, all went into effect in September of this year, and so they're all in effect now. Some of the trafficking ones I will try to mention the effective date of those. Okay, so in this slide, I want to just give kind of the full flavor of the federal law, and then I'll drill down, as I said, on the trafficking and normalcy pieces. But just as an overview, Subtitle A contains the trafficking provision. So just as an overview, that includes requirements for the state to identify, document, and determine services for children who are or are at risk of sex trafficking, to identify and report data on trafficking, and to locate and respond to children who have run away from foster care. And then Subtitle B is kind of the focus of a lot of the presentation. That's what I'm calling the normalcy provisions, and that includes provisions to implement the reasonable and prudent parent standard. We'll talk more about that, but just as an overview, that allows foster parents the authority, liability protections, and training to allow foster children to do some of the normal, quote-unquote, day-to-day activities that they're not always have not historically been able to do when in foster care. It eliminates the permanency objective of APLA, which stands for Another Planned Permanent Living Arrangement, which is independent living in Nebraska for youth under the age of 16. There are provisions to involve youth age 14 or older in case planning, to provide youth 14 or older with a notice of their rights, and to require discharge documents for youth aging out of care, and we'll kind of come back through those. Subtitle C establishes a National Advisory Committee on Sex Trafficking of Children and Youth in the U.S. And then Title II of Subtitle C does several things. It reauthorizes the Adoption Incentives Program. It extends the Family Connections Grant Program. It requires states to reinvest savings from federal changes a few years ago to the Adoption Assistance Program. It preserves subsidy eligibility for successor guardians. I'm going to pause here on this one. This doesn't happen, I don't think, very often, but when it does, it's important. If a child is guardianshipped from foster care and their guardian dies or becomes incapacitated, and this allows that guardianship subsidy to continue on to a successor guardian. And then also within Title II requires data collection concerning failed adoption and guardianships. And then also within this, there's a requirement for notification of parents of a sibling when a child is removed from parental custody. So parent of a sibling could mean step-parent, children with a different dad, adoptive parents of a sibling, etc. So states must include in the class of people who will be notified. So under Fostering Connections, the Fostering Connections Act of 2008, the federal law, there was a requirement that states provide notice within 30 days of a child's removal to certain relatives, and this adds within that class of individuals who must be notified, again, parents of a sibling of the child in foster care. And then, that's what I was just talking about. Then the last one, not keeping up with the PowerPoint here, but the last one there, Title III, is a provision regarding improving international child support recovery. I am not going to cover that because it's outside my area, but you know it's in there now. Okay, so I want to just talk a little bit of an overview of Nebraska implementation of this federal law. With regard to trafficking, there is work underway on the trafficking aspects of this, including a trafficking task force. That's led by Stephen Patrick O'Meara at the Attorney General's Office. And the Attorney General's Office released a plan earlier this fall with the efforts that the Attorney General's Office will be taking with others to address trafficking issues in the state. And then Senator Moorfield introduced an interim study specifically looking at services for trafficking victims in the state, and there is much more work that needs to be done there. There is also a stakeholder group on the normalcy side that was recently established as a task force under the Nebraska Children's Commission. That group with young people through Project Everlast are very involved with that. met over the summer and fall to develop some recommendations not only for how to implement the baseline requirements of the new federal law in Nebraska, but how we can kind of go beyond that and implement best practices. So some of you may have participated in a survey or focus groups. We did focus groups with young people, with foster parents, and there's one being set up with parents also, and then a survey that went out to a range of stakeholders, including attorneys and judges and others. We got through the focus groups and surveys feedback from over 300 stakeholders. And then that, as part of that feedback was collected, the stakeholder group released a report for how to fully implement the normalcy provisions of the SFA in Nebraska in October as part of an interim study that was introduced by Senator Kathy Campbell, and that report's available. It's available online if you're interested. But for the purposes of the presentation today, I just want to kind of flag for you that we expect there may be a bill brought this session to bring our state statute into compliance with federal law, just consistency, and also implementing some of those stakeholder recommendations, as well as some likely changes to policy going forward. The Department of Health and Human Services has said that they put into place some kind of baseline regulations that are in the process, but they're working as part of that partnership in that stakeholder group to really kind of to go above and beyond, as I think we did for the Federal Fostering Connections Act, so there may be some policy changes as well moving forward. So that's something to watch as practitioners, and we'll try to keep you informed of that as well. Also, as I mentioned, the Department of Health and Human Services, in advance of the SFA provisions going into effect, the normalcy provisions of it going into effect on September 29, 2015, the department issued a policy memo on the reasonable and prudent parent standard and another policy memo on transitional living planning. And the department, as I mentioned, has proposed regulations regarding the reasonable and prudent parent standard, which had a public hearing in October. And then finally, I want to mention there was a bill last session, LB 298, that was introduced by Senator Coulterman to implement that sibling notice provision to further clarify that I mentioned in the overview slide. So to further clarify that that the notice applies to parents who have legal custody of a sibling of the child, and that the definition of sibling includes those who would have been considered a sibling but for a termination of parental rights, and those considered a sibling under Nebraska law. So that is kind of the one piece of the Federal Strengthening Families Act that has already been made as a change to our statute. Okay, so I'm going to walk through some of the trafficking provisions of the federal law, and a bit more specifically. The SFA requires states to develop and implement policies to identify, document, and determine services for youth who are or are at risk of becoming victims of trafficking, of sex trafficking in particular. And states need to develop those policies by September of 2015 and demonstrate implementation of them by September of 16. And then there are provisions about identifying and reporting data on trafficking. So states have to report the number of children identified as sex trafficking victims. That needs to be included in the AFGARs, which is some of the data that the state provides to the federal government. States must report annually to the federal HHS agency the number of sex trafficking victims, and then the federal agency must report to Congress on the number of sex trafficking victims reported by the 4 agencies. That's starting in September of 2018 and annually thereafter. And then states must implement policies that the State Child Welfare Agency must report sex trafficking victims to law enforcement and the National Crime Information Center within 24 hours. That's starting in September of 2016. And then there are also requirements about locating and responding to children who run away from foster care. Within this, states must develop and implement policies to locate children missing from foster care, to determine factors that led the child leaving and how they can be addressed, and to determine the child's experience while absent from foster care, including whether the child is involved in sex trafficking. And those went into effect in September of 2015 and are part of the plan that I mentioned. And then states must develop reporting policies around that as well. To report children who are missing from foster care must be made to the National Center for Missing and Exploited Children and to law enforcement within 24 hours so that the information can be entered into the National Crime Information Center database. That's starting in September 2016. A bit about Nebraska law on trafficking. This is the definition in 2830, excuse me, and I'm just going to read it. Sex trafficking of a minor means knowingly recruiting, enticing, harboring, transporting, providing, or obtaining by any means, or knowingly attempting to recruit, entice, harbor, transport, provide, or obtain by any means a minor for the purpose of having such minor engage in commercial sexual activity, sexually explicit performance, or the production of pornography, or cause or attempt to cause a minor to engage in commercial sexual activity, sexually explicit performance, or the production of pornography. We also have in our statute a definition of labor trafficking. And I want to just pause here to, kind of mention why I think this is especially relevant to our work as juvenile court practitioners. So unfortunately, there is an overrepresentation of youth in foster care, and with foster care experience among trafficking victims, it's really hard to get data in this area, which is one reason I think that's really great that the new federal law is requiring states to provide some of that data. So there's varying estimates of this, but I think one New York study estimated that as many as 85% of trafficking victims had prior experience in the child welfare system. So that, that's part of the reason that Appleseed has gotten involved in this work, because of the work that we do in the area of child welfare. And I also just want to kind of connect the dots, because there's been a lot of conversation, I think, nationally in the child welfare advocacy community, at least that I've been a part of, that it's not a coincidence. It's purposeful that this new federal law puts together the normalcy and the trafficking pieces. It's included together because there's a connection. This is all about vulnerable children. And if we can connect children that are vulnerable with some of the normal, again, in quote-unquote, childhood experiences, and get them connected with permanency and supportive adult connections, which is part of the kind of that normalcy piece of this as well. We know that those things are really important to kids' social development. That can help them become connected and resilient. And so these two things, and it can help to prevent sex trafficking. So the prevention side is really connected to the permanency and normalcy aspect as well. So again, it's very purposeful that these are put in that federal law, in this federal law together. So I want to mention a little bit about kind of some of the recent changes to Nebraska law around trafficking. Nebraska is ahead of the curve in some ways in this area, and that is thanks in large part to a bill brought by Senator Amanda McGill in 2013. That bill, I think among some other things, decriminalized trafficking in that it provides an affirmative defense to criminal charges of prosecution for victims of trafficking. And then for children under 18 who cannot consent, they are per se victims of trafficking and are immune from prosecution. And the law requires them to be placed in temporary custody of HHS under 43-285 and referred to HHS. So we have some good policy on the books about how we handle these cases, not criminally. And then this past session, I want to mention Senator Scheer also brought a bill which does several things. It enhances civil protections for victims of trafficking and created a fund for trafficking victims. And then a few thoughts about what attorneys can do when you're working with a child who is or may be a victim of trafficking. Again, the federal law requires HHS to identify and provide services, and as an attorney working with a child, particularly in the child welfare system, you can provide oversight to make sure that that happens as part of HHS's obligations that are now explicit under federal law. So that's a big piece of it. But in terms of practically what you can do as an attorney, as I mentioned, we have a policy brief on this that Appleseed released a couple years ago. That's in your materials. I do want to note that it is a couple years old, so it does not include some of the new law that I just mentioned. But the practice tips that are in there we hope will still be helpful. And the first step is really awareness that this does happen in our communities. It happens in Nebraska and it happens across the state, unfortunately, and specifically awareness about the overlap with the foster care system. And this is because of some of the risk factors for trafficking, like abuse and neglect, runaway and homelessness, that make foster youth more susceptible. And in the policy brief, it contains some common warning signs. Another critical consideration as an attorney when you're working with a child or youth who is or may be a victim of trafficking is that your role as a GAL is different than if your role is as an attorney for the child. I can't really emphasize that enough. So a GAL must advocate for the child's best interest, but a client-directed attorney must advocate for the express wishes of their client. And that can get kind of tricky with our dual role as well. So that, I think, needs to be in the forefront of any actions that you may be taking when you're representing a child, again, who is or may be a victim of trafficking. If you suspect a child with whom you're working is or may be a victim of trafficking, the client interview can be difficult and it should be approached very carefully. So attorneys should really proceed with caution. This is a forensic situation, so our suggestion would be to work with HHS, the Child Advocacy Centers, again, all within the context of what is appropriate based on your role. However, in some cases it might be appropriate and necessary for an attorney to ask some preliminary questions to kind of identify whether a child may be a victim in order to refer a child to the appropriate services and in order to protect their rights, and the policy brief provides some suggestions on how to do that sensitively. Other considerations with victims of trafficking should be, of course, the health and safety of the child. Some national guidelines that we saw suggest within the first 72 hours that you should be assessed for physical safety and a safety plan created in collaboration with community providers, an assessment of the appropriateness of the child or youth placement, including the likelihood that the youth could come into contact with the trafficker. Again, other things to consider: no contact order, trauma-informed services, and immigration relief. Just that is often, in many cases, a primary source of leverage that the trafficker uses to gain control of the victim. So we encourage attorneys to help the child that they may be working with to address those issues as well. But again, these things very much depend on whether the attorney is serving as GAL or client-directed attorney. And then finally, prevention. As I said at the beginning of this slide here, it's really about identifying risk factors, but with all the children that you're working with, to help them get access to services to prevent them from becoming a victim of sex trafficking is really important as well, which is a great segue into the normalcy pieces of the presentation. But I do just want to pause here to ask if there are any questions. I'm not seeing any, but if there are any questions on the trafficking aspect before I move on to the normalcy side. Okay, seeing none, you can still ask questions throughout. I'm not closing questions on trafficking, so you can ask those at the end. Excuse me, or anytime. Okay. I'm going to kind of skip this because I already gave an overview of this subtitle. Okay, so jumping right into the normalcy aspects of the law. And the first one is the reasonable and prudent parent standard. And I just want to give a little bit of a context for what, excuse me, let me get a drink of water. Excuse me. I want to just give a little bit of a kind of context for what I mean when I say normalcy. And the best way that I can do that is to share a story about, or relay a story that a person named Jennifer Rodriguez gave when she came to Nebraska to testify as part of Senator Campbell's interim study on this. Jennifer Rodriguez was herself in the child welfare and juvenile justice systems in California, and then she became involved with their organization for current and former foster youth, much like Project Everlast in Nebraska. And when she was part of that group, she helped to advocate for California's reasonable and prudent parent standard, which was passed several years before the federal one. And then she went on to law school and is now the executive director of the Youth Law Center in California. And so she was here to talk, again, to testify and also to speak at a luncheon about what normalcy really means and what states can learn from California's early implementation of this reasonable and prudent parent standard. And what she said, in terms of what normalcy means to her, is She relayed that as a child and youth in the child welfare and juvenile justice system in California, she learned a lot of things. She said that she knew how to tongue medication, she knew how to make group home staff quit their jobs and cry, but she never had many of the normal day-to-day growing up experiences that most children have. So she had never had a sleepover. She never played on a sports team. She said she never had a family dinner. And we know now from the research that these types of experiences are really important and crucial for kids' social development. And so that is what this provision is all about. It's really is monumental for children in foster care, and a really exciting opportunity under federal law and now for states to implement it. So the reasonable prudent parent standard gives caregivers of children out of home care the authority to make judgments and allow children access to these types of activities. I'll give you here's the federal definition of the reasonable and prudent parent standard. It is a standard characterized by careful and sensible parental decisions that maintain the health, safety, and best interests of the child, while at the same time encouraging the emotional and developmental growth of the child, that a caregiver shall use when determining whether to allow a child in foster care to participate in extracurricular, enrichment, cultural, and social activities. So that's kind of the domain there of what the decision making, what types of activities we're talking about: extracurricular, enrichment, cultural, and social activities. And then the term age developmentally appropriate, that's used a lot in the federal law. That means activities or items that are generally accepted as suitable for children of the same chronological age or level of maturity that are determined to be developmentally appropriate for the child based on the development of cognitive, emotional, physical, and behavioral capacities that are typical for an age or age group. This federal law, under federal law, this applies to both foster family homes and child care institutions. So foster family homes is easy, that's foster parents basically, and child care institutions are basically, that's a federal term for basically our group homes, or I think serving under 25 children. The federal law also requires that contracts with those child care institutions, those group homes, must contain the requirement that each facility has on site a designated individual 24/7 who can act as a reasonable and prudent parent to make those decisions. And then states must certify that they have the skills and knowledge to use the standard. So essentially this is a training requirement. And then the SFA also requires states to implement policies to provide caregivers with liability protection when exercising the reasonable and prudent parent standard. HHS has included in their proposed regulations a statement that the department cannot take the licensing action for conduct solely involving the foster parent's exercise of the reasonable and prudent parent standard. But I think there's consensus now that we need to also look at amending our state statute to include some more specific liability protections. So an update on, or kind of a little overview of where we're at currently with Nebraska law and policy around this. 390 NAC 11 is HHS's regulation in this area. And when I looked back at that, that's our existing regulation on the books. It's kind of the way it read really well. It's kind of what you would want to see for most of these areas. You can see there at the bottom of the slide, it covers lots of different of these kind of day-to-day experiences, like purchasing a vehicle, getting a driver's license, photographs, name changes. I don't think the reasonable prudent parent standard applies to all those areas, like medical treatment. I don't think is an area in some cases where the reasonable prudent parent standard would apply. But with regard to some of these day-to-day decisions that are covered in this regulation, basically what the regulation says is that the caseworker should talk to everyone. The caseworker should talk to the foster parent, the caseworker should talk to the parent, the caseworker should talk to the GAL and make a decision. And again, that's kind of the way you would want it to be. You want everybody to be consulted and involved, but you can also see that when that has to happen, that's why we can't, it's kind of too bureaucratic, and we are not empowering foster parents to make some of those decisions that sometimes need to happen quickly to enable a child to participate in a sleepover or something, a weekend trip or something like that for a school activity. Currently, our conclusion is that Nebraska will need to amend those regulations and statute to permit caretakers to use a reasonable and prudent parent standard and to include liability protections. HHS, as I said, has issued proposed regulations regarding the reasonable prudent parent standard, but that 390 NAC 11 is still on the book. So I think that's something that will need to be taken a look at, again, both in terms of regulatory change, but also statutory change going forward. And, yeah, and there's a policy memo as well on the reasonable and prudent parent standard. Okay, so within each of these provisions that I'm going to be talking about, we have a list of what I'm calling policy and practice considerations, as well as questions to ask from the bench. The questions to ask from the bench are contained in the normalcy guide for court stakeholders that Sarah emailed out to you just before the webinar. And so that is a guide that Appleseed created and have disseminated to juvenile court judges across the state. But we think that's helpful to attorneys as well. If you're practicing in juvenile court, then it's helpful to know, hopefully, we hope that judges will ask those questions in court, and we hope you as attorneys will be prepared to answer those questions in court regarding these areas. So I'm going to kind of walk through some of these. So policy and practice considerations, what training should be provided to caregivers and others? Many of these questions are ones that the stakeholder group is talking about. How will this be implemented in group home settings? How will payment be handled for costs associated with normalcy activities, such as extracurricular activities, sports, etc.? I have a 9-year-old. Some of these sports get really expensive, and that brings in a lot of, a lot of cultural considerations and considerations about if reunification is the goal. You want to give kids access to activities, but is that going to be able to maintain, and what level of activities is appropriate? So there's been lots of conversations about that as well. And then this one's really important, I think. What is the balance of rights and authority between foster parents, biological parents, HHS, the court, and the child and youth? So, the lawyer in all of us, these rights, the bundle of sticks, if you will, for a child in foster care, what are the rights that the foster parents have, the biological parents, it's just the court of the child, what are the rights and authority that all those parties possess? In many areas, that's gray right now, and this new federal law, as exciting as it is, it further shifts that delicate balance. And so, again, it's exciting, but how can Nebraska law and policy best balance and respect those rights, all within the goal of giving kids access to these activities that we know are important for them? So, again, important discussion. In terms of questions to ask from the bench, what extracurricular activities is the youth involved in? We hope judges will be asking young people and their attorneys as well. What opportunities has the youth had to socialize with his or her peers? Has a child traveled? Does a young person have a job? What activities does a child wish to participate in? And then what barriers has the caregiver experienced in connecting the youth with cultural and social activities? And one more is the youth participating in the activities that he or she would like to, and if not, why not? Okay. So moving over to APLA. Again, this is the federal term for the permanency objective of another planned permanent living arrangement, or what was previously under ASFA termed long-term foster care. So in other words, having a planned response for a child for whom other permanency goals like reunification, adoption, or guardianship are not appropriate. And again, in Nebraska, this is our independent living. And the concern here at the federal level is that APLA had become sort of an easy way out for states who often look to residential placements or other forms of congregate care for youth rather than attempting to re-engage family members or other adult supports to provide those permanent connections. Another concern I think at the federal level was that in some cases some very young children were being appropriate or even just kind of middle childhood age children were being inappropriately placed in APLA. So essentially we were kind of giving up too soon. So the SFA requires states to eliminate the use of APLA for youth under age 16. So it can't be a permanency objective for youth under age 16 going forward. And kids that are under 16, I don't think we have too many in Nebraska, but that currently have independent living as their permanency objective, that needs to be changed. And then at each permanency review for youth age 16 or older, so those are youth who could have a plan of APLA under federal law, there are requirements for the state agency and the court. The state agency must document the intensive and ongoing efforts to find a family placement, to document the steps the agency is taking to ensure that the child's caregiver is following the reasonable and prudent parent standards. So some oversight in this piece of the earlier slides, and document the steps the agency is taking to ensure that the child has regular ongoing opportunities to engage in age and developmentally appropriate activities, including consulting with the child in an age-appropriate manner about the opportunities to participate in those activities. And then, as I said, there's some oversight on the court here as well. The court must ask the child about their desired permanency plan, and I believe the federal law actually uses the word ask, so there's an implication there that the child is in court. And then the court must also make a finding explaining why, as of the date of the hearing, APLA is the best permanency plan for the child and provide compelling reasons why it is not in the child's best interest to be placed with a parent, relative, or in a guardianship or adoption. Okay. So HHS, as I said, has issued a policy memo on reasonable prudent parent standard, and also one with regard to APLA on transitional living planning, and that outlines the documentation that must occur at each age, so caseworkers have a guide. But existing Nebraska statute currently allows APLA as a permanency objective of last resort, but there's no age requirement. And then requires transition planning beginning at age 16, but doesn't specify some of the documentation regarding efforts for family placement, reasonable prudent parent standard, and age-appropriate activities. And then the court findings are not in existing state statutes, so just to note, we have, I think, some tweaks to make here. And then considerations. As I said, the court is required to ask the child about their desired permanency plan, so how can we strengthen efforts to have children attend court and encourage their participation? I know there's been a lot of efforts in recent years around kids in court, but how can we keep going on that train and make it better and really encourage their participation? Because the federal law, I think, really does imply that they're there. And how does the required consultation with the child about opportunities to engage in age-appropriate activities, how can that be done in a youth-friendly and meaningful way? And then the state agency must document steps to ensure the foster parents following the reasonable prudent parent standard, but how can we, should they have to document communication with a biological parent around that decision making? Again, we don't want to like slow down the process, but in terms of longer term family team meetings and planning, the parents should be involved in that, and how can we make sure that that's happening? Questions to ask from the bench. We think judges should be asking, what's the youth's desired permanency outcome? What efforts has the agency made for family placement? Kind of drilling down on that, those family finding efforts. And then if APLA is listed as a permanency goal, is that in the child's best interest? If so, why? Why is it not in the child's best interest to be returned home, or to have one of the kind of more preferred permanency goals there? And then what are the steps that the child welfare agency is taking to ensure that the reasonable prudent parent standard is being followed, and what opportunities has the youth had to engage in those age and developmentally appropriate activities? Okay, in terms of youth participation in case planning, the SFA requires that for youth aged 14 or older, that the case plan shall be developed in consultation with the child, and at the option of the child, up to 2 members of the case planning team who are chosen by the child and who are not a foster parent of or a caseworker for the child. The federal law specifies that at least one of these individuals may be designated as the child's advisor and as necessary advocate with respect to the application of the reasonable and prudent parent standard and for the child and normalcy activities. So it's kind of interesting to think about who that normalcy advisor could be and to help children identify that person. And then the federal law provides that the state may reject an individual selected by the child to be a member of the team at any time if the state has good cause to believe that the individual would not act in the best interest of the child. And then the federal law also states that the case plan must describe the services needed for the youth to transition to a successful adulthood. And I like to just pause here because this is a small thing, but I think it's really significant. It's a small thing that's a big thing that I think. So the Congress here struck the term independent living and inserted the term successful adulthood. And I think that means 2 things. I think it means, one, you know, independent living is a good goal. I think by that we mean that we want kids to grow into adults and be self-sufficient as adults. And so we do hope that young people will be independent in a sense of self-sufficient, but not in the sense of being on their own, not independent as in disconnected and on their own. We want them to be instead connected to supportive adults. So I think that's significant. And then I think the term successful adult is a higher bar. We're not just connecting, the obligation is not just to connect them to services to help them be self-sufficient, but to help them transition to successful adulthood. I think that's consistent with the focus on the federal level with well-being of children, in addition to focusing on safety and permanency. So I want to make sure we had drawn some attention to that. Okay, again, HHS has a policy memo related to this aspect of the SFA, but existing Nebraska statutes are still a little off here. I think it's in part because in Nebraska we have some good law implementing the Fostering Connections Act, again of 2008, and the SFA made some changes to the Fostering Connections Act. So we were in compliance with that, and now there's been some tweaks with this new law. So, for example, existing Nebraska statute requires HHS to develop a transition plan at the direction and involvement of the child to prepare for the transition from foster care to adulthood for youth age 16 or older, but it needs to be 14 now under federal law. It doesn't include the successful adulthood language. And then the existing Nebraska statute also requires a transition plan to be developed in collaboration with the child's transition team and lists individuals which shall comprise that team, but it's not specific that the state agency document that, and that the child's been given opportunity to involve two individuals who are not the foster parent or the caseworker staff. So again, we just have some tweaks there. Okay, in terms of policy and practice considerations, what are best practices for authentically engaging young people in case planning, and how can case planning in Nebraska be more youth-led? How can we support young people in identifying supportive individuals on their team and make that, you know, have meaning, not just an exercise, that we're actually helping them to identify those people that can be involved in their case planning, but it can also potentially be people that are more longer-term supports to them. How can we incorporate the option to have a child's advisor on normalcy? Who might play that role? How can it be helpful to young people? And how does the advisor interact with other individuals or professionals in the case? And then I told you already my answer to this question. It's a leading question. What does it mean that the goal was to help young people transition to independent living is now a successful adulthood? It means we're going to be doing better. That's what it means. And then some questions to ask from the bench. Is the youth involved in the development of his or her case plan? Which individuals did the youth choose to be a part of his or her case planning team? If the state rejected an individual selected by the youth, what were the reasons for rejecting that individual? Oops, those were only two, I guess. Okay, and the next is the rights notification. This is also very exciting. Some people have been calling this a Bill of Rights for foster children and youth. I may even be guilty of that. It is a notice of rights. Beginning at age 14, the SFA requires the states to document in the case plan, along with the youth signature, that the youth has been provided a copy of their rights and explain to them in an age-appropriate way. And under federal law, the list of rights must at least include the rights of the child with respect to education, health, visitation, core participation, and the right to be provided with their credit report and assistance in repairing any problems, and to be provided with a copy of their birth certificate, social security card, health insurance information, medical records, and state ID or driver's license, and the right to stay safe and avoid exploitation. So this is kind of a connection to the trafficking side of this as well. Okay, I'm going to pause here because I'm so excited. It looks like I have a question. Okay, this is a great question. The question is, and thank you very much for the question, what services can HHS offer that are specific to sex trafficking victims who are adults with children? Is there an HHS policy about ideal service plans for parents who are victims? And so I want to make sure I understand this question, because I was thinking it was asking about, and so feel free to clarify, person who chatted, that there, I was thinking about, we have many youth in foster care who are themselves parents. And there's been a lot of efforts lately to talk about pregnant or parenting youth in foster care, and so I think that is an area that I know HHS is working on, and that the advocacy and kind of service provider community is working on pregnant and parenting youth in the system, and how can we make sure that we're helping not to continue the cycle and to help them be successful parents. So I thought that it was asking about that, but I'm confused because it says parents, victims who are adults with children. So maybe it's asking, just thinking through this out loud here, if a child in foster care who is a parent who is a victim. So, but I think either way, it goes back to what I said about the effort around services. Again, Senator Moorfeld introduced an interim study specifically to look at what services do we have in the state for victims of trafficking, and there are some, and a number of providers that are doing this work, but we need more. Like within many areas of the work that we do, there's a need for more services. Oh, I got a clarification. I am asking about a victim who is a young adult. Okay, yeah, thank you. And part of that interim study was also like, let's look around the country and try to identify a best practice model of how to serve victims of trafficking, and try to bring that to Nebraska. And I don't want to oversimplify it, but there is no like one answer of what is the best service. There are some promising practices out there, and so I think that there are some efforts underway to improve what we have, the service array in Nebraska around this, but there's still a lot of work to do there. So thank you for your question. Okay, hold on now. Okay. So back on the rights notification in Nebraska, HHS policy now requires youth to be provided with a list of rights, but there is nothing in statute or regulation. Existing Nebraska statute requires youth to get a copy of their credit report, but at age 16, not 14, as required by the SFA. HHS indicates that their policy is 14, so that should be consistent. It is consistent with federal law, but may need a tweak again to the statute there. And then policy and practice considerations on notice of rights. What rights exist, and what enforcement mechanisms should be put into place? I think that this is a really important question, and one that, again, is part of some of the stakeholder conversations that I've been a part of. It's really exciting that young people now will get a notice of what their rights are, because we hear from so many young people, not only do they not understand their rights, but in some of those focus groups, young people didn't even understand like which system they were in. We would ask if they're in foster care, juvenile justice, or we try to put it in youth-friendly language, and there's a lot of confusion about even just kind of the basic way that the system works, and about their rights. And so, the young people that we've worked with are very excited about this, but I think it's important that we take a look about what rights they do have. What do we mean when we say rights? And if there has been a rights violation, what can we do about that? What enforcement mechanisms that exist or could be put into place to help actually address it when the rights of youth and children in the system have been violated? And then, when should the list of rights be provided to youth and their signature obtained? And how can we intersect the trafficking work with the requirement to notify youth of their right to be safe and avoid exploitation? And then questions to ask from the bench. Has the youth received a copy of their rights? The judge can do some oversight to make sure this is happening. And does the youth have any questions about their rights? I also want to say, because I'm talking to a group of attorneys, that I think this is a really important piece for guardian ad litem as well. The obligation under federal law is put on the department to provide them with this notice, to get their signature, to explain in a developmentally appropriate way. But I think it's also an obligation, or part of the guardian ad litem's role, to be making sure that that's happening as well, and to help explain those rights, and to check in with the child about whether they think that their rights have been violated. And in that case, I think a GAL could raise, again, being conscientious of the dual role, could raise in confidentiality and explaining what applies there or doesn't apply, but raising those issues with the court on behalf of the child. But really, that's an important role of the guardian ad litem on this provision as well. Has the agency conducted a credit report for the youth? Were there any inadequacy reports, and how were those resolved? In talking with young people, they also want just an explanation of what the credit report even is and how that works. That's important for a successful adulthood. Okay, and then I think the last one here is pre-discharge documents. So as part of the case review system, the SFA requires state agencies to provide youth leaving care at age 18 or older who have been in foster care at least 6 months. So I think this includes young adults who are exiting our extended program, the Bridge to Independence program, to be provided, you can see the list there, a copy of their birth certificate, social security card, health insurance information, medical records, and then state or ID or driver's license if they're eligible to receive such document. And I want to just pause here on kind of the why of this, and hopefully that's self-evident to most of you, but these documents really are essential to ensuring youth have what they need when they're aging out, to secure housing, to apply for school or work, to get appropriate health and mental health care, and to access other forms of assistance. So we really need to make sure it's important that young people, as they're exiting care, have these documents so that they can get connected to some of the adult services and rights that they have. In terms of in Nebraska, with regard to the pre-discharge documents, HHS policy now requires caseworkers to provide youth with these documents as required by the SFA, but our existing Nebraska statute, again, is close but needs some tweaks to track the federal language. It requires HHS to facilitate securing a social security card and all documentation required for enrollment in the Medicaid category, the new Medicaid category under the ACA for former foster youth, but it doesn't specify other health information, medical records, state ID or driver's license, and does not include the people that are exiting the Bridge to Independence program. And then I want to just mention another best practice nationally is to provide youth exiting care with a reference letter verifying the child's information and their former ward status. This can help with access to Medicaid for the former foster care child category, with college loans and scholarships and other benefits. So this is something you can advocate as an attorney and that we think should be considered as part of law, policy, and practice related to this. Okay, so some policy and practice considerations. Are there other documents that would be helpful for young people that should be provided as a best practice? What is the best process for providing these documents, and how should they be implemented into the transition planning process? With the credit report, there's some room here, I think, to help explain to young people why these documents are important. And also, explain to young people how they can get them again in the future. So if they get a discharge packet, but then they might lose that, and so how do you actually, if you need to get it again, how can you get that in the future? That's kind of an important piece of the learning as well. How can this be youth directed? What does health insurance information entail? The federal law references that, but not sure exactly what that means. And then what additional help is needed to assist undocumented youth who are aging out of care? I want to pause just on that one as well. There's a number of young people in the foster care system that are undocumented may have a claim to special immigrant juvenile status or other forms of immigration relief. And so that's an important piece of this as young people are preparing to exit foster care, that particularly as attorneys representing them, to help them with that process, or probably more appropriately to refer them to attorneys who could help them with any immigration relief that they may have. That is really crucial to their ability to become self-sufficient as an adult, if they may have a claim to a type of immigration relief that they can't. I think that SIJS, if you don't get it before you exit care, you're no longer able to access that immigration relief. So just wanted to flag that as part of this piece of federal law. It's not in federal law, but we think that needs to be happening. I know there's some conversations happening in Omaha around that. And then questions to ask from the bench. Has the youth been provided with his or her birth certificate, social security card, health insurance information, medical records, state-issued ID, just checking in with the young person about whether they received those documents. And then has the youth been provided, if the youth has not been provided with one or more of these documents, what steps is the agency taking to make sure that they get them? Okay, and with that, that brings us to kind of our last slide here, I think. And I would invite any additional questions or discussion you have in the chat function. We'd love to know, have these issues come up in your practice, or what challenges or opportunities do you see with this new law? I'll pause just a minute to see if anyone wants to engage with me here in the chat function. But if not, I'll keep talking and hope that somebody chats me. If not, I invite you also to reach out to us at Appleseed if you have any thoughts about this or any suggestions in terms of policy going forward, or if you would like to be a part of the stakeholder group. Again, that is now a task force under the Nebraska Children's Commission, and so we welcome the involvement, particularly of attorneys and judges. We've had several meetings to date, and one contingent that I think has been underrepresented in that effort has been representatives from court stakeholders, because I know it's hard to get away from your practices to do that, and for judges with their busy dockets as well. But as you can see from the presentation, there is a really big piece of this that is the court implementation. And so we'd really love to have some more practicing attorneys involved in the effort. So if you're interested in participating in that we're calling it, I think it will be called the Normalcy Task Force. I'm co-chairing that with Katie McLeod-Stevenson, who is the director of the Court Improvement Project. Please just shoot me an email and let me know that. We did get, again, a lot of feedback from attorneys and judges as part of the survey. But if you'd like to get more involved in the process, please let me know. Okay, well, seeing no additional questions, and I think we're close enough to 1 o'clock, I will sign off. But there is my contact information, my phone number, and my email, and please feel free to reach out if you have any follow-up questions or just want to chat about it. Thanks so much for joining today, and happy holidays, happy new year to all.